So go ahead and open them however you want to, Dick.
Yeah, well, we just started on these minutes and they shouldn't take us very long.
Sign that.
Mhm.
So I'm on July 13th. Is that what everybody's got? There's copies if you need them.
Yeah.
It's online as well. It was a fairly short meeting because we sort of went through the last bit of it and then Matt made his generous offer and we broke up, adjourned.
On line 11, it's Erickson, Elof Erickson with an I.
Yep. Thank you.
And on line 10, is his first name Brain? Or Brian?
Oh.
Might like to go by Brain.
Right, yeah. Brain and Brian are both words and I called him Brainhampton,
Oh, good.
so he might like to be Brian. Thank you.
Later on, towards the end, asking the applicant to abide by its representative, that increased tower. It's either its representation,
What line are you on?
20 or 30, excuse me.
30, okay.
It's either, I mean, I'm not sure how, and maybe Matt can say. The lawyer represents the applicant, therefore speaks for the applicant. Is that right? So anything he says, the applicant is bound by?
Yes,
Okay. So maybe you can say by its representation that increased. Or by his
I was just
representation,
gonna say.
by his representation.
Okay.
And then,
it should say,
pardon?
should say fourth tenant, not additional tenant.
Okay. but how-
Because there's only one right now.
Right.
All right,
So we're not talking about the second one,
Okay.
talking about the fourth one.
okay.
right.
And on line 33.
Yep.
I'd put a comma after that, cross out as. And put with consolidation, comma.
Yep.
I don't
Yeah,
know, I couldn't.
something
And you might wanna say market consolidation,
couldn't
just so
sense
people
that.
know what you're talking about.
And
With,
line,
right, with, carrier consolidation.
Yes.
Most towers in town have.
perfect, yeah,
Yeah,
okay.
yeah.
I'm trying to be
Getting smaller,
minimalist.
they're just.
Yeah.
The market.
Would have thought GP.
And line 37. I don't think you need also. And a comma after attorney.
Okay.
Yeah, his main job is being on the zoning board, but he's also a land use attorney.
You know, he's got his priorities, right?
Brad's also the land manager, we're also, everybody's also something or other,
Not anymore.
You're not something or other anymore?
No,
We're talking. Okay, I got it.
all right, any other comments on the minutes?
I mean, they be accepted as amended.
Do you have a
Is it
preference
supported?
on
Second it.
Second.
that book?
Any further
We're about to
discussion?
get new ones.
All those in favor?
To consolidate.
All right.
Do you have a preference as to a paper copy or a digital copy?
I don't really need the paper one.
Digital.
Digital is fine.
Okay, got it.
Can't read what they write in that any.
Talk to Matt
It'd be
about
the
that.
same either.
I do
way.
not have 20/10 vision.
Oh.
You good pair of readers?
Even with the contacts, it ain't good.
All right, so we ready to roll? Let me see. That's the folder, I probably don't need it though.
Right, if you need it, there it is though.
Okay.
And there is drafts, if anybody in the audience would like a copy, there is a draft of the decision, it's posted on the website.
I wanna,
That's the draft that Matt worked on, and so I'll let it go from there. So
I want to bring up right at the beginning here, right up front, that we closed the public hearing. This meeting is a continuation for deliberation by the board. And so hopefully we can just make a decision, make a good one.
So I wrote this decision based on the straw poll that we took the last time. Where the general sense of the board was that we were looking to approve the tower, but at a height of 120 feet rather than 130 feet. So this is my attempt to put that into words based on what I've observed from the past meetings. But we're not bound to approve the tower if by deliberating over this decision, we find ourselves coming out the other way and think that a variance isn't warranted in this case, we can still come out the other way. But, you know, other than that, I was most concerned about making sure that I got my head around the law of how the variance criteria work with the federal law overlay. So I feel pretty good about that, but, you know, with respect to the findings of fact and conclusions of law, those are the things that my mind seized on. And should not be considered an exhaustive list of everything that was discussed and that was relevant, so. Feel free to add and subtract and
The one thing that
edit all.
I
this.
remembered from the two, I missed one of them, yeah, I was gone, but 2 meetings back. That, and I don't know, I don't think it's a big point, but I did want to say it out loud so that you understood what I felt about it.
I'm gonna say it out loud.
This. So. Somewhere along the way, a comment was made about, or an assertion was made about the fact that a parcel in Lebanon shouldn't be considered, or parcels as a more general statement about things in Lebanon shouldn't be considered because they went against Lebanon's zoning ordinance. And I felt like, well, the insinuation there is that somehow one town's zoning ordinance had more weight than another. And again, I think it's a minor point.
No, I think the rationale behind that, though, was the specific ordinance. They were talking about part of the ordinance, and that was the steep slopes. Because even without the ordinance, the steep slopes, you know, the reason for the ordinance
Right.
is reason enough not to want to build something like a tower there.
So this is something that I've wondered. At some point, it feels like we're being asked to side with a business interest because the economics aren't favorable to them in some fashion. And that doesn't seem to be, I wouldn't have thought that's our purview.
What economics are you talking about?
The development of a steep slope. The development of a lot that might need a longer driveway. Now, I come down in our particulars with thinking we're headed in the right direction. But if the case were slightly different, if it were not that, if two parcels were otherwise equal and one was in our turf and under our consideration, and another seemed equally viable on surface, we shouldn't be accepting somebody's argument, or it should not add weight to their argument to cite the fact that it is against the other municipalities' ordinance.
But it's, that even in discussion of one of the sites anyway, in Plainfield, they cited the same reason.
Right, and
That is the basis for the ordinance in Lebanon. We just don't have an ordinance about steep slopes. But for the same reasons, it was impractical to build the tower. Probably dangerous and far more disruptive to the environment in the area than it is to put it in a more modest location.
okay, so I would agree with that phrasing, right? That there is an existing road in one spot, there is not an existing road in another. And so to the community, the abutters, the environment that's being directly affected, the impact, the change is less. And so if everything else were equal about the two sites, that would be in favor of the one that requires less development. But as soon as it gets to the point where you're trying to say there is it's somehow more costly. Nobody asked them.
We never said
to
that.
Be in that business in the first place, so
They
they
never-
couldn't be guaranteed or that they always get the least cost solution.
Cost was not part of the discussion there. The thing is, think about it, what do you have to do if you're gonna try to build access and then a flat pad on a steep slope? You have to rip out a lot of material, you have to terrace everything, you have to
Right,
do,
but that part of it.
you're gonna make a real mess.
I think you're a little confused because Matt did use expense as part of the discussion, but that was, when we were talking about it last week, we did not. We talked about the fact that the expense should not be part of the hardship, because the hardship was regard to something.
Okay, so if that got addressed in the meeting and I missed, then I'm back to not having an issue in general. But anyway,
Yeah, one thing I just wanted to put in your head, if you want, I think there's only one here tonight, I don't see any waiting on Zoom. But given that abutters can appeal the decision
Mhm.
and may be considering an appeal, is it possible that you would let them comment on the draft for understanding purposes?
No,
I don't think so.
Okay,
There's no new information to comment on.
but the new information is the draft.
It's not new.
Well, it's new as of today. I mean, it was posted on the website today.
no, it's
This
a
is all-
motion, it's a motion, we would, at the meeting, we made a motion, the public and the.
Right, my preference is always to let anybody that took time enough to come to a meeting have a say if they're not rehashing old information, but I'm not the chair, so I don't get to make that decision. And so,
That's not, we've never done it that way.
I
If
think
there's
we've got a
new-
long history of always letting people speak.
If there's new information, or if for some reason there were people that couldn't make it to earlier meetings,
And my only thought is that it might eliminate litigation if they knew what the board was thinking on a particular subject. They can find out by suing us, but why not give them a chance to say, what did you mean by
you
that?
don't think they know by now?
I don't know, because I'm saying my piece.
There's 9 pages of what we think, I think.
and what were you suggesting, Steve? Post it, like share, screen share? I'm not.
Well, I mean,
I'm asking what
it's
you were
on the
thinking.
website. No, but I'm thinking like, Mr. Healy has come tonight.
Yeah.
He has something to say. What's the harm in letting him say it?
Oh, based on his already having considered that
Yeah,
information.
because
which is now
they have
publicly
the
available.
decision.
Yeah.
Hey, what did you mean on paragraph 3? I don't understand that.
One of the problems too, Steve, is that, we closed the public hearing on the last meeting.
Okay, no,
There are people who might not have shown up because they were pretty sure they wouldn't have a chance to speak. They didn't expect to. There's no expectation of the public speaking in this.
I've said my piece. You guys run your meeting any way you want.
Yeah. I think are on reasonably firm ground
Yeah,
here.
I'm not arguing with you. I'm just having said what I've said. I always prefer to let people speak.
That said, if you really have a serious comment, you take Steve aside and you can, have it out with him, but.
All right, I'll let you guys deliberate, so maybe we can get home before it's dark.
I'm impressed with how well this reads, man. I sat down
Yeah.
and read this and went, oh my God.
I thank you
Yeah,
for spending the time to turn it into something that's really, for me, was very coherent. And it brought in just about everything that I was thinking ought to be somewhere in the record. And it's a complex thing, so thanks for the extra. That was a huge.
Yeah, I didn't wanna rush it and try to get something out there half-baked, and because this is a decision that's attracted a lot of attention, I thought it was worthwhile to be pretty thorough.
Yeah.
With everything, and try to lay it all out as plainly as we could.
I've been trying to think about procedure here, and this is a draft decision. Do we have a motion to accept the draft decision as final, or do we have to read the draft decision out loud in the form of a motion?
I'd like to have some further discussion first.
Well, we can't. I wasn't
Okay.
suggesting we're
Okay.
ready
Okay.
to vote on that, but I was trying to think about procedure.
Well, as part of the motion, we can waive reading it,
I would assume, yeah.
can't we? Sure.
Yeah. Right, I mean, as long as our final motion, whatever it is clear and unambiguous. And if it's going in the direction of granting a variance. Essentially for the reasons stated of whatever we end up with in writing after we edit this, then. You
In,
know,
in the past, we've had a draft motion made. And then written, commented and modified, and I wonder whether or not, because of the last meeting, whether we had a straw vote, whether you could say that the sense of this motion could be voted on, and then we could talk about details or not, because we're talking about the details before the motion, and it might be voted down.
Well, we already did a straw vote,
Okay, that's fine, if things haven't changed.
and these are the details, and we're discussing the details now. And if we hash out the details and agree on them
Well, that's
sufficiently.
at the beginning, that this is not a fait accompli that we can
No.
vote it down.
Right,
Okay,
it could be. No, on two different levels, we could reject
okay,
this as a motion, as a decision. Or we could reject the whole variance,
Sure.
you know, in a separate.
Yep.
You know, it's two different levels there.
Did the applicant through Attorney Swinarski, is the language that you were putting in there about the height of the pole and the intent of reserving the ability of title, the additional.
You gotta speak a little louder.
for me, anyway, I don't care about anybody else, but for me.
Sorry,
with the ability to increase the height of the tower.
so that's a point of law, and I assume they weren't interested in committing to something other than that, than reserving the right to follow the law. But other than that, did they agree with that premise of that height?
Yes,
Okay,
Yeah, at the last meeting, that was Peter's concern was that it's, the proposal was hundred and 30 feet to accommodate 4 carriers.
Right.
Each carrier's antennas taking up approximately 8 feet,
yeah,
right? And there was discussion at the last meeting about, at this point, they only have one carrier interested in attaching to the pole. Peter pointed out that we really only more or less have 3 potential carriers operating in New Hampshire right now, so the foreseeable odds of needing a 4th carrier are a little bit small. And then we talked about how under RSA 12K, you can do a modification of a wireless facility without going back to land use review, as long as it's not a quote unquote substantial modification. And a substantial modification requires land use review, zoning and planning again. But what makes it substantial is if you're increasing the height of your tower by 10%.
okay.
So if
And
you're
that's-
staying under that 10%, then you can increase the height of your tower without coming back to the ZBA again.
And the 10% came from a previous case.
The 10% is in the RSA,
it's a federal.
and no, that's in the state
okay,
law,
sorry.
RSA 12K. So essentially where it falls is the applicant was amenable to reducing the tower height to 120 feet, which would accommodate 3 carriers and reduce the visual impact, with the knowledge and the ZBA having the knowledge that if they ever need a 4th carrier, they will have the right to increase without coming back to
Right.
the zoning board or the planning board. They'll just have to submit a building permit. And we know as a practical matter, or we understand as a practical matter as well, that once you've built a pole like this, you're unlikely to be incentivized to really incur the cost of increasing it for one more carrier. So it may be something that is legally possible, but practically much less likely.
I'd like to follow up on that, in that when you say that we granted the variance for their application, we've modified their application to 120 from 130. Should that somewhere be in the first paragraph?
It couldn't hurt.
I mean, in the conclusion is there for sure, and the discussion is there, but the application itself, it says that we're giving them the variance on their application.
You're saying at that, in the very first
Their
paragraph
first
there?
paragraph, yeah.
Yeah, so that's why I underlined it to bring to our attention that it's a variance. For the erection of a wireless communication facility consisting of 120 plus or minus foot pole, but your point is that they applied for 130.
Right, when you say that we're giving them a variance to their application, their application said hundred and thirty feet. That's,
They modified their application based on our request, though.
did they? I mean, I'm just, they agreed to that, to our condition. I don't know whether they
That's-
modified the
That's,
application.
that's a modification of the application, I think,
Okay, fine.
legally. I mean, if
That's
they agree to a change that you suggest, that's a change.
That's fine.
There
We're
have to be
being
anything
sticklers
in
for
writing.
detail, and if that's the answer, that's great.
So
That's-
Matt, tell me. And I understand your argument or your reasoning for the number of carriers and the number of slots. I just wanna understand how the town office would pursue this. They go to site plan review, finish that with the planning board, and we can imagine what some of the issues are gonna be at site plan review, access to it and road condition and legal status and all of that. They get through that and they come for a building permit. Can they ask for the 10% immediately? Can they just make or is the only building permit the town should approve at 120 feet?
I think the latter.
I mean, that's how I read it.
Well,
Yeah.
we've said that,
But if they walked in and said, hey, we got 3 carriers and a 4th is on the works, we're going 130.
I'd want a fourth
Well,
written in blood.
I mean, that is their modification then, right?
Right, you get one modification?
Well, if,
So if you made it
What-
130, you couldn't come back for one, whatever, 10% of that?
No,
no,
14 more?
it's whatever you're originally approved to build,
plus 10%.
you've got 10% or,
Right, I mean, I think
Whatever
if
the
the
other
building
math
permit
is.
came in at 120, we know, easy, done. If it came in at 130, I just don't know what to do with that. Do I bring it back here?
Say no.
You just say no.
Well,
Yeah.
because
You just
twelve
say
K,
no.
Nancy
do
Reagan
anything
said
to
that.
procedure.
yeah, 12K talks about, modification applications. So I don't think you can have a modification application if you haven't had
If
an
it-
original
Okay, so
application
the
yet.
building permit the town would approve, and, the applicant is here by his attorney, is for a 120-foot tower if this were to be approved. That's the,
Correct.
that's the
So
tower.
if in fact you get an application for a 130-foot tower, you would say, no, the decision said 120 feet.
Right. Under RSA
They could
12K,
litigate
yeah.
that before they build or whatever.
Or they can
but-
come back to the ZBA and tell
But
them
they would
why.
have to come back and we'd have to have. a
No, and I
conversation.
don't wanna belabor it, I just wanna be
No,
sure it's
that's-
clear in
that's a
my
good-
mind
Good thought.
what the building permit's gonna say.
Yeah.
Right, yeah, a modification as defined in this RSA 12K is the replacement or alteration of an existing facility.
So it would have to,
So you
not design.
you can't avail yourself of a modification to increase the height if it's not an existing facility.
Physical
Got it, thank
facility,
you.
not a design.
Right, so Peter, to address um. Your point about 120 feet versus 130 feet. Maybe just insert the words as amended, right? You're hereby notified that. The application of Atlantic Tower for a variance or waiver, blah, 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 for
That
the
would be,
WCF
yeah.
as amended,
that would be great.
consisting of,
Thank you.
all right.
There's a couple of places where we, per ZO sections, is that a common, like there should be Plainfield zoning, or actually that's zoning ordinance, but. Is that, were you just doing that for brevity in
It's-
your document?
Reference in the first paragraph is Plainfield zoning or.
Oh, look at that.
Yeah, that's just my shorthand, because I
Yeah,
get
no.
tired of
No.
typing zoning
right,
ordinance over and
right
over
there at the
again.
beginning where it ought to be. Thank you.
There are a couple of things on page 6.
Okay,
And the second paragraph. The sentence that says that about 1240 is necessary to enable carriers' antennas to have a line of sight. That seems to imply that elevation is required for the carrier to use it, and that's the top of the pole rather than further down. I don't know whether you could use the lowest number and have 3 go up rather than use the highest number and go down.
I see what you mean. I didn't try to use the lowest number and go up because I didn't wanna get that number wrong.
I'm just,
It
probably
doesn't
doesn't
say
matter.
how far above the canopy it is.
pardon?
It doesn't say how far above the canopy it is.
Well, he's using elevation himself. That's, I mean, he's at 1240
No,
elevation.
But it said at that elevation, it would be above the canopy.
So I think it's a little challenging, and maybe there's a way to so with modern GPS, you can say right there, that spot is that elevation within 1/8 of an inch. And in earlier discussions, they talk about the site being approximately, and then by the time they're done with foundations and.
I mean, you could just say that that's the highest tower to
There's a
allow
range.
3
But if you
carriers.
Start putting specific elevations as being, as Peter's discussing, as some threshold that someone could rely on later, it feels a little bit problematic. So I don't know if we can make it all a little more plus or minusy, or whether we want to go the other direction and say, somebody's got to put a pin in the ground literally and say, this is the base
No,
elevation.
I'm not-
And I don't really
I'm-
care.
I'm not
Right.
saying that we need to have that particular number. I'm saying that using that number as the highest,
Right.
as the line of sight implies that we need that for all carriers.
Exact, or even just that site, and I think even that's not necessarily true. So I don't know if it is or not. What I think is, though, we should be careful about using any particular number. And so maybe we should not, and maybe there's a better way to phrase it.
Well, we want to have enough in here to say we thought about it,
Yeah,
and so I
And
think that's
so-
important.
well, we could ask the applicant if they have, how precise their elevation numbers are. And say, okay, can we agree on a number?
We've already said that they can have it at 120 feet,
Right,
and I'd like this paragraph to back that up.
120 feet from where, though, is sort of my question.
It's
And so-
from the basis, from the ground level.
So that's what I was working from was the ground level is a little bit higher than 1,120 feet at the location where the pole's gonna be. So add 120 to 1120, that's where you get the approximately 1240. So Peter, to address your question, what if we say that the approximately 1,240 feet elevation at this particular location,
Would serve 3 carriers.
is necessary to enable 3 carriers antennas mounted on the monopole to have a line of sight with all areas in the coverage gap.
Yep.
Yeah,
That,
that would be fine. I don't think we need quite as many numbers there. I agree with Peter on that.
okay,
Because they're not clearly a point. The point is that 120 feet is good. Works.
Yeah, but Matt's gone through this exercise so completely to make sure that it really shows what we're doing and not have to come back and say, what did you mean by that? We was here. What do I mean by that?
No, but I think his suggestion is good. I think it's a good way to reword it. It makes the point clear.
The next paragraph, 7, it should be 8. I think.
Sorry,
Identified 7 other geographically viable, and there were 8.
right, 7 others in Plainfield plus 1 in Lebanon
Okay, thank you.
is the 8.
Perfect, yep, you're right. There were
Which I didn't-
8 total, I didn't see.
Yeah, which I didn't catch the first time when we were
Yeah.
looking through this. I thought all 8 were in Plainfield, but then there was one in Lebanon, which was one of the coal properties that we were
There's a-
asking about later anyway.
There's a hyphen in the next to last paragraph, the first line. I don't think you mean that. Maybe you do,
RC2,
potentially hyphen available.
oh, potentially. Potentially available sites, yeah. Yeah, probably not.
The first line of the second paragraph up.
Yep.
But
Still on page 6.
yes, if the applicant credibly represented. Potentially available.
Oh, thank you.
I don't know, I didn't.
Got it.
Yeah, I think so. I think you're right.
And there are 3 other minor. Things. On page 7. Last paragraph. In several places throughout, you've said that the representative credibly testified. In this paragraph, I'd like to take out the word credibly. Because you go on to say later that nothing was substantiated by either side.
Okay,
And I presume in this context, credibly means we believe that.
that is the intent of the word, yes.
Yes, okay. The meaning of the word is that we believe them.
Well, right, when I indicate that somebody credibly testified, that's us
There is
finding
a
that
logic
we're
path.
relying on the fact of their testimony.
Okay, I didn't want to rely on that particularly.
Well,
but
Good,
That's
That,
okay.
that's what I think you have a good point, so.
Next page 8. After follows, I think it should be a colon instead of a period.
Yep,
And this is getting back to one of the things that Brad was talking about finances. Instead of alternative sites will increase cost for the applicant, which will be passed on to the consumer. I think it might be reasonable if you say which may be passed on to the consumer. That decreases the impact of it with regard to our decision, and we don't know what's gonna happen.
yeah, I'm fine with that.
And the last thing I have is on the next page. On the height restriction. The end of the second line. Provide 4,
Yeah.
and the beginning of the next line 4.
4-4.
There's another one in this sentence too, very nearby. Another typo.
Yes, I wanted to show that I read it.
I guess you read it better than I did. I missed that.
Well, by page 10, you're probably running out of endurance.
Well, we'll see how it came in.
Taking cheap shots at attorneys.
Kind of like Charles Dickens, we get paid by the hour instead of paid by the word, but it's the same idea.
Okay, do we have comments from other people on parts of it? Specific. Things are comments on the whole of it for them, so.
And you'd said last time you weren't persuaded whether a variance was,
I think it's well written,
you don't have,
minor amendments aside, minor typos and double words aside, well written.
I didn't start off there.
So I have a question.
I was, I could make a case the other way, but not as thoroughly as you did.
I-
In other words, my reading of your analysis, I could not say, no, I don't agree with that, and therefore I end up in a different place. And so I'm not where I thought I was. But at this point, I'm supportive.
I think that the math analysis of the, what'd you call it, the TOC? the, Federal law on this,
The TCA, the Telecommunications
yeah.
Act.
It gave me a better, understanding of how we needed to operate underneath that,
Yes, yes,
because that's,
without it just being thrown as the big sticks out there. If you don't do what we want, you're
right.
gonna get hit with it. You
So
know,
it was our job, though, to require the
Right.
information necessary
Yeah.
to make those determinations.
no,
But then, once we did that, once we were satisfied with that information, we were pretty much governed by that federal law and had to act accordingly. So, but we made sure we got all the information, did jump through all the hoops, I think.
You had a question, Peter?
No, I mean, sure. On page 4.
Yeah.
The fact that id comes down a different place, is that because of like you quoting something and then it just has to be? This is just form, but
Right, that's just citations of legal briefs.
no, so the citation goes down there rather than at the, I mean, this. It's weird that it just sort of sits out there in space, but
At the end of the quoted indented paragraph?
Yeah.
Yeah, so if you do a block quote,
then you go back to the.
Then you go back to-
Regardless of what you're doing, even if it's
right, you go back out to a full paragraph when you're
Okay.
out of the block quote.
I was gonna ask you afterwards about that, but you saw me questioning.
It's a legal order.
what is that, an LA standard or something?
Blue book. Something like that.
No, following up on what, Dick said about getting all the information. That's, Matt helped us with that too, or did, he wasn't not just read this thing, he helped us through the whole process.
Yeah, well, he's got more experience with it than we have. I don't know how we made it through the.
How long have you
other
been on this
towers
board?
yet. No, we still do. 31 years.
Long time.
Yeah, so
Is this the first one applicant for an RC2 zone? Or-
Yes,
Oh, sure.
yeah.
That's
first
what I
one like
thought.
that, yeah.
yeah, so that's the trick of these, and it was rereading the Daniels v. Londonderry case that clicked it for me. The concept that the Telecommunications Act relaxes the unnecessary hardship criteria on the variance. So the thing that I was getting tripped up on was there's not, in a traditional variance analysis sense, there's not a hardship on this property owner if they can't have a cell tower at this location. Because that lot can be used for a
Lots of
single
other
family
things.
dwelling, it can be used for agriculture, silviculture,
Right.
whatever,
Yeah.
so on. So there's not a hardship where it needs the constitutional escape valve of variance in order to make productive use of this land. It's the overlay of the federal law saying that we really want to incentivize and make cell towers able to be built. And so look at, for your hardship analysis, look at what is the hardship of locating a cell tower that will serve this coverage gap. If it can't go here, what are the alternatives? And that's what puts us into the analysis of, is there really a significant coverage gap? And then is there really no feasible alternative that, where it could be done as a special exception?
And one of the other things is, and the neighbors appropriately say, well, why are we doing this when Lebanon's getting most of the use out of it? It's a federal thing where it's for the general population, the general good, and towns don't matter,
Sadly.
I think.
That's one.
Well, I mean, I make the case, and this, I think this came through in my coverage gap analysis, that it's the commuters on Route 120 that are getting the most
Right.
benefit out of this.
True.
You know, East Plainfield Village is not densely populated. The rest of the corridor up through, up to La Plante or whatever is not
Right.
densely populated, but
It's not the marginal users in.
3,000
that live there.
2,700 trips
Yeah,
a
that's-
day, or 3,000 or more trips a day up and down
Yeah, that's a lot.
120, and that's, that's everybody from Claremont and points south up through.
I bet you I've
Hanover.
driven, I mean, I've been here 35 years and driven that road thousands of times. And I
Yeah.
had to look up both those roads that you used as references.
But if I showed you a picture of them, you'd know them in
Sure,
a second.
yeah.
Absolutely, I know there was a road there, but I didn't know what the names of them were.
Right,
Yeah.
exactly what those roads are, which, by the way, there's 2 new driveway entrances along 120,
Yeah,
right? Just
Right.
in the last week
Right,
or so,
Don
which,
Goodwin is starting a logging operation there. We've had some people confused it with the tower project because of just the development, but Don Goodwin has bought that property. Is gonna subdivide it into 2 lots, gonna sell the 2 plus the one across the street. But the permanent driveway, he's gotta go to Ross Wood for that logging driveway, and if they did, great, if they didn't, they'd be on them. But yes, but what you're seeing is not the driveway for the proposed house. The driveway will be the same as the one that's there now, the permanent drive. But I assume he's got that approval from the state. It would be pretty aggressive to just cut out onto 120 without any state approval, but we'll see.
What do we do with this?
Well, I entertain a motion. I think we've gone through, Peter did a good job of pointing out a few larger issues and a lot of little ones. And prompted a lot of good discussion from us and a few changes. I think we've worked it over pretty well.
I move we dispense with the reading of the motion as amended and pass it.
But be specific about the draft, so and so, as
Okay.
amended.
and we'll state for the record that people voting in support of a motion to approve this written decision agree with the findings of fact and conclusions of law stated herein, and you've all read those and are in agreement with them at this point, correct?
So moved.
And if you vote to approve the motion,
Right,
that would be part of the understanding.
okay. Is it supported?
yeah. Sure, I'll second it.
Okay. Is there further discussion on it? Are we ready for a vote then? Okay, all those in favor of the motion? All those opposed?
Perspective.
But that's sufficient, right? There's no call for the chair to vote on this. I just looked it up after all these years,
You only need to vote on a tiebreaker.
or a tie creator. Those, and it's not need to vote, can vote. And I think the extra case we have, and I don't know how typical this is, because it's not in Robert's, but is if there are only 3 of us, then I have to vote.
Right, She doesn't need to vote if you need to get to majority of the board.
Yeah, if there are only 3 of us in the.
You know, there's 4 people here and it's 2 to 1.
Yeah.
You can vote to tie or vote to move forward. Yeah.
I mean, do you want to discuss why you are against it, so that maybe change minds? I mean, that part of the discussion?
No, I made my, I have not changed my thoughts on the conclusion
Okay.
since the last meeting.
I have thought about that quite a bit.
And there's no need to rehash. It's a well-written decision. It's supported by the facts of the meetings. when it comes to the conclusions and path forward, I do not agree with them I don't agree with it, so.
That's fair enough. I
And
just want to see. what
Maybe,
they-
maybe my approach would lose in a court of law, and maybe it wouldn't, but we'll never find out.
Well, you may get a chance, I mean, it ain't over yet, but you know, butters have rights.
Mhm.
Well, if butters are concerned about this, the next step is for them to file a motion for rehearing.
Yeah,
And they would then set forth what issues of fact or conclusions of law we missed or got wrong. And then we would have the opportunity to re-examine those.
right, and if they wish to do that, there are a few details, I think it's outlined here clearly, you know, in the.
Right, I get confused and we should be clear. The clock starts tonight, even though the decision may not be available for a day or two. Is
That's
that
right.
right? It doesn't start the day the decision comes out. The clock starts the
Right.
night of the vote.
It's the day of the
But-
vote, right?
But any written motion for a rehearing needs to have the entire argument included in that written motion. There's no oral presentation of it or anything like that. It's just the written motion.
And it's a 30-day clock.
I believe so, yeah, 30 days.
Yep.
And then if we deny the rehearing, then is it a fresh clock to appeal?
Yes,
yeah,
To the, to Superior Court?
Yes. All right, Steve, I did track changes of the things that Peter,
Right, you'll
So
clean it all up, send me no watermark, no nothing, ready to go.
right,
And,
We should keep you around.
Matt's language to add to the motion somewhere is gonna be,
Yeah,
be in the minutes.
yes, it'll be in the minute, and I've got it on the recording, so I can refer to it, but he'll send me a clean copy, which I'll distribute and get to Dick for signature. I've been on a track for these last couple of years, where I just swing over to his house and get it signed, just.
It's the safe way. We had
Right.
one that never showed up when I mailed it back to you.
Right, it turns out, depending on the mood of the postal department at any day, if you're sending something to Plainfield from Meriden, it might go directly to Plainfield, or it may go to Connecticut. That's just, it depends on what they do with the bag. And so we, a trip to Connecticut to get 7 miles over to Dick's house seems ridiculous, so.
why don't you just run over, walk over,
Right.
get some exercise.
I can do that, so, but I'll get it from Matt, I'll send it to you guys, and then I'll make arrangements with Dick to get it signed. It'll be part of the record, but the 30-day clock for appeal starts tonight. Go from there, and it's as Matt said, it's a rehearing to the board is the first step.
Right.
May I move that we adjourn?
Second,
All those in favor?
Aye.
Very good.
Thanks, everyone. Have a good night.
Chris.
Yeah, he was unusual.